money loan law. We're going to explore what happens if you have a purchase money loan, but then you refinance. We're going to do it quickly. We're going to take a look at upsidedownrealestate.com here. We're going to put me in the corner, and we're going to search 580B, and we're going to see the gold standard. This is, we talk about, you want to look at these things from a deficiency standpoint, a tax standpoint, a credit standpoint. So on 580B, we're going to look at this from what it is. It says purchase money loans in California. If your money went into the purchase of the house, 1 to 4 units, there's other qualifying parameters. But if you're an individual or couple, you bought a house, the money that you used to purchase, the money you borrowed that you used to purchase that property, it's 580B protected. It's called purchase money loans. Purchase money loans are non-recourse loans. That means unless you committed fraud, as far as I can tell, no matter what you do, if the bank forecloses, if you do a short sale, I would not sign anything to the contrary, because banks all the time, if you're doing a deed in lieu or short sale or a short payoff, it wouldn't make sense on a short payoff, but they still might try it. They try to get you to reaffirm the debt or agree that you'll pay them later or other things. And so as long as you do it well, it's executed well, and the law says it's very hard to waive, you're not going to owe the bank money if you do it right, if it's a purchase money loan. Your IRS, as I just covered in 580E, the logic is that if you're not personally responsible for the loan, the cancellation of debt income is an income to you. So if you might get a 1099-C, but with a letter from a lawyer, or you could do it on your own. My clients get letters from me, and I explain why the debt's actually characterized as a 580B and therefore non-recourse, and no one's ever had a problem. I did that probably for 100 people back over the years, maybe more. Now, if with respect to credit, unfortunately, some of these laws have been tested, and there's a Shaw versus Experian case where they're like, although the law says it goes back to as if they're getting paid in full, it's not owed or collected, and no deficiency shall lie. The argument that since I got it back in full, there shouldn't be any damage to your credit. I don't even know why they call it Metro 2, because I looked it up again. It's still there. They're now saying it's a Metro 2 code they use. It's the same thing as what they did 10 or 15 years ago. It was legally paid in full, but settled for less than full amount or the equivalent. And that's a signal to every lender down the line for the next 2 to 7 years, depending on how the lender wants to look at it, that you didn't pay them back in full. I wouldn't accept that argument. It's a risk. I therefore give my clients, you could pay me to fight this, but if you're working with me and you're doing a walkaway plan or short pay or short sale, I give you some letters that I would send out immediately upon the event happening and try to block them from reporting it incorrectly. But with respect to this law and the way we would fight it that way, I can't charge you for it because I think it should work, but it won't. It might work better when other things besides a foreclosure, and when you avail yourself of other protections besides a foreclosure. But the good news is this statute gives you tons of leverage over the bank. With the foreclosure timeline being out over a year, when you're giving the bank options and you're saying, work with me now and you'll get the property back right away or you'll get paid. You take this deed in lieu. Don't damage my credit. I'll work this out with you. Or you'll get the property because I have a lawyer and he knows how to extend the timeline. You're not going to get the property back for over a year. And in those last few months, when I've moved on, I'm going to put a seller in there so we don't break the law, so there's no waste. So I'll have the money to maintain the property, and it's going to be slightly below market because it's in a foreclosure, and we have to explain that. I mean, you're not going to get this property back for a long time. That's 12 to 15 months if you're good, Mr. Banker, Mr. Negotiator, at $6,000, $8,000, $10,000 a month, wherever you are. That's a significant portion of your, it's basically more than, on a 20-year mortgage, it'd be more than 1/20th. Like that's a significant portion. It could be more than 1/30th. I mean, 1/15th even. So, you know, we'll get it done and we'll find ways to protect your credit. I'm just not, I was just being a lawyer. Even though it's getting paid in full, they're going to try to argue that they can still report it to harm your credit. So you're going to need other reasons, and there are, to protect your credit and force the bank's hands. My name is John McConnon. I'm a real estate attorney and a broker. We have a free consult. Right now it's free at upsidedownrealestate.com. You can type in strategysession.upsidedownrealestate.com, or let me see, is it know your options? Oh, wait, I got to click over here. Know your options. Did I put the form on there? Yeah. Thanks. My name is John McConnon. I will talk to you later. Bye.